Hello and welcome to Newscentre. I'm Parikshit Luthra. The government has introduced the Competition Amendment Bill with changes which could have massive implications for big tech companies. The bill was introduced in Lok Sabha after factoring in recommendations of the Parliamentary Committee on Finance. The bill proposes to levy penalty on the global turnover instead of the domestic turnover in case of violations. The new law, once by Parliament, could regulate mergers and acquisitions. Combination deals, FDI proposals and corporate insolvency resolution cases would have to be decided within 150 days as opposed to 210 days currently. Also, the Competition Commission of India would have to give a prima facie view within 30 days as opposed to 20 days earlier. The government plans to move the bill for discussion and passage in this session of Parliament. Joining me now to take this forward is Dhanendra Kumar, the former and first chairman of the Competition Commission of India. Mr. Kumar, thank you very much for joining us. These are some changes with far-reaching implications. But let's begin with the issue of deal value threshold. After examining the amendments, could you tell us if the deal value threshold will be periodically reviewed, as was the recommendation of the Parliamentary Committee?
Thank you so much for giving me this opportunity to talk to your viewers. It's a pleasure and a privilege. Before I begin answering your questions, let me take 2 minutes just to set the stage with the background of these amendments. The Competition Law 2002, which was starting enforcement in 2009, a lot of water has flown under the bridge since then, 2009 until 2023. The new age economy, the digital economy, and the massive changes with data-based economy has resulted in a number of players acquiring dominance and big position in the market. And in this position, particularly considering the fact that India is poised to become the third largest economy in the world, it's already fifth, and it's going to be most populous country during this year, maybe overtaking China. It is important to have a fresh look at the economy and the digital economy in particular. What are the tools needed for the competition law in order to speed up the economic growth, which is the main focus of the preamble of the competition. So the first question which you raised was about the deal value threshold. Let me mention in a few minutes that in the digital economy, it is important that in the mergers and acquisition, when a company acquires another company, it's not only the assets and turnover which should be seen, but also the value of the deal, because it is based not only on the assets and turnovers, but also on other factors like the data which it carries, like the technology which it carries. And just to give you an example, Facebook acquired WhatsApp in 2014 for $19 billion at that time. And the turnover in 6 months of the WhatsApp was only, I think, about 25 or so $million. So and you know what WhatsApp today is. Half the country is using this, half of India. So it is not only the assets and turnovers, but also the deal value, which is important. And that in the digital economy should be an additional and important criterion. So therefore, in the suggested amendments which are being brought before the Parliament, in addition to the assets and turnovers, the deal value threshold is being included as one of the important parameters for the Competition Commission of India to look at. And it would necessitate if the deal value threshold is above a stipulated threshold, these transactions to be notified to the Competition Commission for being reviewed. So that, in my view, is a very important and very needed kind of amendment which is required.
Okay, now speaking about the definition of turnover, this is perhaps one of the biggest changes. The penalty under the CCI law will now be imposed, if this law is passed, on the global turnover of a firm rather than the turnover in the relevant or domestic market. How important is this change in the current global scenario?
Well, it's a very important change, undoubtedly, And this would definitely have a lot of implications for digital enterprises, particularly the so-called big tech, when their entire turnover is being considered. And also the fact that it would also include maybe the exports. But the fact remains that in a digital economy, when the entire economy is interconnected globally on the digital platform, and sometimes the transactions and their economic import is beyond the frontiers of the country, it is probably relevant to look at the global turnover, although much can be said on both sides. And the Supreme Court, for example, in the case of Excel Corp case, had held that the penalty should be levied on the relevant turnover, but it's for the parliament if they have, if the government has brought up this amendment, and there are logical and very valid reasons in the case of internet economy and the platform-based economy, the digital one, that the whole thing is considered and must be brought in, kept in mind that India is very important in terms of digital economy, and for G20 also, this is considered to be, this is one of the focus areas that we are talking about.
Right. Recently, the Parliamentary Committee on Finance had also recommended an ex-ante regulation to regulate big tech companies which have the position to dominate the market. Now, the government has set up a committee. These changes that have now been proposed to Parliament in the law, the ex-ante regulation is separate, but how do these regulations compare to the regulations across the world? And could there be certain challenges in the implementation of these new laws?
Well, as you very rightly pointed out, that one of the recommendations of the Parliamentary Standing Committee on Finance headed by Mr. Jayant Sinha, the 53rd report, there was a mention about the constitution enactment of a Digital Market Act on the pattern of the European law. And this law was enacted in November 2022. We do not have much of experience to see its functioning there and how far it would be relevant for India. But yes, there is a case for it. CCI, in any case, has been considering to set up a digital market unit, DMU, which would be manned by experts who would be in a position to assess, to analyze the impact of digital enterprises. And this is likely to come up soon. It has to be seen whether that would be enough, or we need to have a separate Digital Market Act on the pattern of EU, or should we wait for some more time to see the results of the functioning of that Digital Market Act in Europe and elsewhere also?
Right. Now, on the issue of mergers and acquisitions, the time frame from 210 days will come down to 150 days if this law is passed by Parliament. Do you think this will be good for mergers and acquisitions? On the whole, this law will make it easier to go for combinations, for FDI proposals to get early clearances?
Absolutely. In my view, it is a very investor-friendly amendment which is being brought. When I was chairman of the CCI in 2009, the combinations were introduced in 2011. And at that time, we had assured industry that it would not mean any delays in the M&A and investment promotion for India. And we had laid down a stipulated limit of 30 days at that time. And the 210 days, this was the statutory limit. We assured at that time it would be about 180. Now it is being brought down further to 150. I think it's a very, very positive and forward-looking move. Total combinations which have been approved by the CCI so far, the number is over 900. And most of the combinations have been approved within a period of 30 days or less. And therefore, they have adhered to the stipulated time limit. Also, they have not blocked a single combination so far. So in terms of ease of doing business, I think India ranks very high. Not only this, one of the very forward-looking amendments, I would say regulatory provisions they made was provision of a green channel route for quick, expeditious approval of straightforward M&A cases. There is no horizontal overlap, and therefore these are straightforward M&A cases. And under the green channel route, which has been globally appreciated, more than 50 cases have been approved, and enterprises find it very convenient. Also, they have encouraged companies to file their M&A cases directly. So I feel that reducing the timeline to 150 days and this 30 days is a very positive and forward-looking move to encourage investments into India.
Right. My final question would be about the CCI not having a chairperson, sir, since October. This has put many deals, very high-value deals, on hold for the past several months. We now believe that this quorum requirement has been waived off, and the existing number of members, that is 2, can go ahead and approve M&A deals and other combination deals. What do you have to say about the fact that the antitrust regulator of the country does not have a full-time chairperson and does not have the quorum available?
You see, when our competition law was enacted, it was hailed as one of the most forward-looking, one of the best acts in the world, because we took the best from everywhere. We were a late starter, but we could pick up the best from everywhere. Now, there is a section 15 in the Act which provides for that in a situation like this, or for that matter, any other similar situation, no decision or order of the Commission would be voided due to any deficiency in the Constitution or quorum or whatever. So the CCI, and I believe the Attorney General has also given his opinion in affirmative. So CCI would be well within their right if they were to decide these pending cases within the existing strength, namely the 2 members. And I believe that today, for example, they are clearing, and they would have cleared by the end of the date by now, many of the cases which have been stuck. So it is a very legal and judicious way of handling the cases. Of course, I'm sure the government would be also considering appointment of a chairperson as also the members for the remaining vacancies. In my view, the government is fully alert and conscious to make sure that the Competition Commission is able to function very effectively and in accordance with the provisions of law.
Okay. All right. We've run out of time, but Mr. Dhanendra Kumar, thank you so much for joining us here, giving us clarity on the amendments to India's competition law and what this will mean for the big tech companies and the new age economy going forward. We're going to take a short break here on Newscentre, but coming up, European Investment Bank has signed a memorandum of understanding with the Indian Hydrogen Alliance and has committed to invest €1 billion over the next few years for green hydrogen projects. An interview with the Vice President of the EIB when we're back. Welcome back. The European Investment Bank has been active in India for about 3 decades, supporting renewable energy projects. It has now signed a memorandum of understanding with the Indian Hydrogen Alliance and committed to invest €1 billion over the next few years for green hydrogen projects. I caught up with Chris Peters, Vice President of the European Investment Bank, and began by asking him about the MOU signed. Listen in.
I've understood, and that is very positive, that India wants to be a very strong player when you talk about green hydrogen. And we have, as European Investment Bank, a lot of experience in green energy. And we have discussed a lot of issues with, for example, the Indian Hydrogen Alliance, very important organizational coalition. And there we announced that we are capable and we are willing to invest €1 billion in India when there are concrete projects about green energy. That is very important. But we also signed an MOU with this Indian Hydrogen Alliance. We also have had discussions with the growth equity fund here in India, and we have also discussed a lot of issues with the metro companies active here in India.
If I were to ask you to lay out some sectors which you see as potential areas of future investments, which you're seriously considering, what would those be?
Yeah, of course, we are a European Investment Bank and project-driven. We are here certainly for making the ambitions of India in the climate change discussion, make that possible. We are a bank, we finance projects, and we need projects. When there are no projects, we can do nothing at all, of course. Dus I hope that in the next period, we have not only important projects about metro public transport infrastructure, but also in, for example, the green energy and hydrogen and a lot of other projects. Dus for us, climate is very important because we are also the climate bank of Europe, not only active in Europe, but also outside of Europe. And once again, India can and must be a very important player, not only in India, but also in the neighborhood countries. And I hope that with our endeavor, with our possibilities, with our knowledge, that we can contribute to make this possible.
Are you also urging the government during this visit to give a roadmap on the kind of projects that are being planned or envisaged for the future so that you can take a call on investments?
Your Prime Minister already launched a lot of very important plans. Also, the goals are very clear. Now we have the discussion, how can we implement that? Because you can say we want to be a frontrunner in green hydrogen, we want to be, and so on and so on. That's good, and that is already on the table. And the government is doing very good work. But now we must see what we can do, not only with the government, but also with the private sector in India, because we need public-private partnerships. That means the government, the private companies and the banks. And in this role of banks, we can play, of course, an important role.
Right. Any investments planned for India for this year in terms of transport, in terms of green hydrogen, in terms of climate action?
Yes, we have already, what I've said, 6 projects when you look to the public transport and in particular the metro. We have already some important projects to invest in metro, but there are also other projects, and I hope that after this mission that we can come back and make more projects possible with our import and support, of finance the projects that are on the table.
Right. I'd like to ask you about G20. India holds the presidency of the G20. What has been the message from EIB to the Indian government, especially on the finance track of the G20, which is really at the core of what G20 stands for?
First of all, it's, I think, very, very important that India has now the presidency of the G20. When you look what is going on in the world, when you look to the war in Ukraine, for example, we need multilateralism. We need to discuss with all the members of the G20 what the problems are. That's the first element. And we are very eager to see what this presidency for India can mean and what also be the result. Secondly, when you look to, for example, the climate change and a lot of other issues related with climate, we need a lot of money. Not only money coming from the public sector, but also from the private sector. And then we need, of course, innovative ideas, how we can finance, for example, once again, this green hydrogen project, how we can convince people that investing in climate projects is so important. And that is, of course, very important to have this G20 debate, this dialogue with all the other countries. And I'm convinced that India shall play a very, very important role to make this G20 a success.
So would you put climate finance at the very core of India's agenda during this year-long presidency?
Well, it's not to me, of course, to decide that. It's the presidency and the other members. We, as European Investment Bank and Climate Bank of the European Union, inside Europe and also outside, are very key to discuss this issue, how we can finance climate change, how we can finance climate mitigation and adaptation and so on. And therefore, we are there, we need the projects, we stimulate every country, and certainly India, to have these projects, and then we can come on board and have a solution when you talk about the finance. This I hope that financing the climate project is one of the most important issues at this moment.
My final question would be about the Ukraine war. We're nearing at least 1 year of the war, unfortunately. Give us a sense of the support that has gone from EIB to rebuilding Ukraine, and at the same time, how has the war, in a way, changed your strategy towards investments across the world?
Well, first of all, it's a terrible war, certainly for the people living there. Every day, soldiers and people are killed by the Russian invasion. That is terrible. And we, as European Investment Bank, we can contribute to the civil society to say you are not alone now. And until now, we invested 1.7 billion euro in infrastructure, in energy and so on, the last months and year. That is very important, to give a very important signal. We, as European Investment Bank, support the Ukraine economy and to try to make projects possible. Secondly, I think that the impact of the war in Ukraine is certainly for Europe very important, because we were until now very dependent on the gas and oil coming from Russia. And we have had a very important discussion how we can be more independent as Europe. And the bank, of course, can also help. And we have supported the initiative Repower EU, coming from the European Commission. And we, as European Investment Bank, have said and decided, okay, we shall be also part of the solution. We shall put extra 30 billion euros on the table to make Europe more independent of oil and gas, certainly coming from Russia.
All right, so that was Chris Peters, the Vice President of European Investment Bank, talking about how the bank intends to support India with $1 billion in investments for the green hydrogen sector, and how they are diversifying investments across the world in light of the Ukraine-Russia war as well. With that, it's a wrap on this edition of Newscentre. Don't go anywhere. News continues on CNBC TV 18.